let's go on to Kenosha and talk about Chrystul Kizer. We're back in Kenosha, Pat, already. Um, and this is a self-defense case, and I'll let you go into it and talk about what happened here and what you think's important. But yeah, this is a young woman who killed her abuser.
Yeah, and so Chrystul Kizer, she's a young girl who was being sex trafficked. It wasn't clear if this if the I don't want to call him a victim, uh, but if the person who was killed, if he was a pimp or if he was some kind of a sex trafficker. But Randall Volar is his name, and she was charged with first degree intentional homicide along with some other charges because she went and murdered him. And I think from what I can tell, she was tried and then there was an appeal. There was an interlocutory appeal, which means that before trial, there's an appeal on an issue because you have to get approval before you can make a self-defense claim. And so she was going through and she was going to make an affirmative defense of self-defense. So that's saying, yes, I admit to killing him, but it was in self-defense. And they're using a new arm of Wisconsin statutes, which under Wisconsin statute 939.46 1M, there's an affirmative defense of coercion. And this is a new law that allows someone who's a victim of sex trafficking to bring the affirmative defense of resisting coercion, frankly, basically.
So
And
I guess just to kind of clarify what you're talking about there, Pat,
yeah,
you're talking about a situation where a young girl's life doesn't necessarily have to be like somebody could kill her right then or rape her right then, but if you are somebody who's essentially like has her kidnapped or held in a way against her will and is in the process of sexually abusing her, either yourself or for someone else to do it, that's cause for like lethal self-defense.
yeah, and that's my understanding. And my understanding is that this is the first time that this affirmative defense has been enacted for the resisting of being sex trafficked and for an intentional homicide. Or sorry, excuse me, at least for an intentional homicide. So it's being used to defend against an intentional homicide under the statute for the first time.
Okay. And so she kills the guy, and she ends up arrested and in jail and everything like that. So I don't know. I mean, how why bring the charges against her in the first place? I guess that's kind of the interesting part to me. It seems somewhat a clear cut case. I mean, right?
Yeah, I think the issue here is recency because it doesn't seem like to me it doesn't appear that Kizer killed him while he was in the act of physically assaulting her. And I think that's the issue is that so here's the background according to the appeal. According to the criminal complaint in June 2018, significant evidence led Kenosha detectives to interview 17-year-old Kizer in relation to the death of a Kenosha man. After lying to the detectives, Kizer admitted to taking an Uber from Milwaukee to the deceased's residence, shooting him because, quote, she had gotten upset and she was tired of him touching her, and then started a fire at the residence before departing in the deceased's BMW. Kizer was charged with first-degree intentional homicide, operating a motor vehicle without owner's consent, arson, possession of a firearm by a felon, and bail jumping, which are all felonies. And so they go further on. At a pretrial conference, Kizer discussed the applicability to her case of Wisconsin Statute 939.461M, which provides an affirmative defense for victims of human trafficking and child sex trafficking for, quote, any offense committed as a direct result of the violation of Wisconsin Statute 940.3022, which are the sex trafficking statutes. So that gives you a little bit of the legal background of this appeal.
All right. Well, so I guess the issue in her case is what they would argue that she wasn't like bound by this guy or something like that, and that's why it's it's questionable. But it seems like, she felt like she couldn't do anything to prevent him from assaulting her again.
Right. Well, the issue on appeal was the they say here in the opinion, quote, a victim of a violation of the sex trafficking statute has an affirmative defense for any offense committed as a direct result of the violation of the sex trafficking statutes, without regard to whether anyone was prosecuted or convicted for the violation of the sex trafficking statutes. So this issue is about whether or not what she did was an offense committed as a direct result of the violation of her being sex trafficked.
Okay.
So in my opinion, I think the court made the correct ruling here, just opening the door to her to present that offense. Now the jury can decide whether or not they buy it.
Yeah. So I guess there's a couple more things. It does seem like by the letter of it, what she said when she was arrested, I was tired of him touching me, right? That's like, she did it because she was tired of being abused by this guy. Yeah, and I guess an interesting part of this, Pat, is that would even be a law that would prevent somebody from raising this defense. I mean, doesn't it just work that anybody could raise any defense and whatever? This is something I addressed because of the Espionage Act, and an objection that like Edward Snowden and Julian Assange have to facing trial in the U.S. is that they couldn't even raise the issue that why they did it was to expose war crimes and everything. You can't argue that. And how exactly is that in like a criminal homicide case? You can't argue self-defense if that's what, no matter how crazy it is. You know what I mean? Like if some self-represented guy wearing a toga wants to go up there and kind of do his own cross-examination, like he should be allowed to do that and raise whatever points he wants. Now, whether that's going to like bode well for him with the jury is one thing, but that the court could like actually restrict that seems wrong.
I think it does. However, we can get into the philosophical difference between like positive law and the common law tradition. Positive law is something that's created by statute, and the common law is something that is created by case law. In this instance, the courts are guided by the legislature, especially in Wisconsin. That's how it works, is that the legislature sets up the frameworks for the procedure, and the court is bound to follow that procedure. And the procedure is that if you are going to present an affirmative defense, the court has to approve whether or not you can present that defense at trial. And that's what this interlocutory appeal is all about, is that my understanding at the circuit court level, her attorneys asked permission from the court to present the affirmative defense. The circuit court said no. They were appealed. Then now the appeals court is saying, yes, that's wrong. So you can get up there and present your own defense with the approval of the court. But of course, I mean, you're free to bring that, but you just have to get the court approval before the trial.
Yeah, it seems like a little bit of a scam.
Yeah.
Yeah, it seems like a way to, restrict and control what happens, especially in front of the jury. And, and this is a case where, unlike Kyle Rittenhouse, isn't, everybody doesn't know about it, right? So you could, like, legitimately have 12 people sitting on that jury who don't know who Chrystul Kizer is or anything like that. And if you're restricting what she's able to say and present in front of them, it could really tie her hands. And I think there are similar other things that happen like with Ross Ulbricht's trial too, right? They couldn't bring up a lot of the malfeasance, even if it was directly related to like what the FBI agents did and stole from Ross. Like that couldn't be brought up at trial. And it seems that these pre-trial kind of things are really just ways for the prosecutor, judge, the police to control what happens in the courtroom.
Yeah, I think that's the way it's effectively used. In a way, you're kind of breaking my brain, because this is very fundamental to my legal education and my legal experience, is the concept that all of these decisions are made before trial. Because what you're really doing is you're balancing rights in this case, because it would be a kangaroo court situation if both sides were just able to throw whatever evidence they wanted into the trial. Um, it to give a clear delivery of justice, you have to have a sieve. You have to have the court act in its function to determine what evidence is relevant, and the probative value outweighed by undue prejudice is what relevance is. So you have relevance here, which is made up of probative value, which is whether something makes a fact more or less likely of being true, and undue prejudice. So in these examples that we gave, this is just the foundation of evidence here, is that you have these competing interests, and evidence can't be admitted if it's unduly prejudicial. Like, I don't know, if I was walking into the store and I'm being charged with stealing something from the store, if we go into the trial and someone says, well, Patrick is an anarchist, how does, that's unduly prejudicial, and it's going to make the jury think that I'm guilty because I'm an anarchist. So you have to make those calls. But I see what you mean. It's like, the jury, these evidential rules seem to be like what the judge and the prosecution used to railroad people like Ross Ulbricht.
I think it's very much weaponized. And just,
Yes.
I guess to go back or push back on that, I mean, there is like perjury, is illegal, and prosecutors like seemingly would not be able to like just lie, right? Like they couldn't like bring false evidence that would like be something that would be held against them. I guess though you do make a good point, especially when it comes to like reputation. If you got like somebody who like went crazy 10 years ago and beat up some old lady, right? And then now 10 years later they robbed a convenience store, and the prosecutor puts you beating the old lady up there. Well, everybody's going to convict you of everything, right? And even if that's like maybe unfair, it's not exactly untrue. And I do see those kind of things causing some problems. But anything else on the Chrystul Kizer case? Is there, I guess, do you have like a thought on how it may go in the Wisconsin courts? If I mean, obviously we have our own opinions, but there's what's the truth and what should be, and then how things will go in an American courtroom.
I think it's interesting. I think it depends on what the makeup of the jury is, and how good the defense counsel can do. I would assume that she's being represented by the public defender's office. Maybe that's an unfair assumption for me to make, but it's an interesting legal question. I'll say that, because you have a novel application of the law. You have an interesting kind of factual argument. And I guess in a sense it's a legal argument. Is this a direct result? It's statutory interpretation. What does direct result mean in this case? And I think that's just from my own legal brain. I think that's a really interesting question. So we'll see how it gets addressed. It could be that she's not allowed to present the self-defense argument. Then I think she might be screwed, unless there's like some kind of a jury nullification that takes place where they refuse to convict her because of her circumstance. Do you remember that case, the famous case of the pedophile who was being walked past a telephone booth, and the dad of the victim?
I know the video. I don't remember like the details of the case at all.
I believe that the father was convicted of homicide, but he was given like a very light sentence. And I wonder if that would be the case in this. I know that the judge has more power to do the sentencing.
Yeah, that is the last point I was actually going to bring up on this, is that, especially when you live in a country like as big as the U.S., as many people in the U.S., like, not that this is like, something that like is absurd that like a girl is being sex trafficked, but, things that don't really fit into everyday law are going to happen. And that's why like pardons exist, and why judges should have discretion is, for cases like this, maybe it really isn't that you have to like have a particular law, or the court system has to be able to like function in a way that, justice for this girl, she's able to go free, but the governor just grants a pardon, and that's like, clean, quick, simple way of handling cases like this. And part of me thinks like that's more the solution here, because I do kind of understand. Not, I guess I'm not necessarily worried if, like, sex trafficking victims just all feel empowered tomorrow to go out and start shooting their abusers, but mistakes happen, and you don't really want people just going out and getting their own justice by carrying out homicides. That's a dangerous route to go on.
Yeah, it is, certainly. And I mean, in a more just system, because I mean, I always remember that it's the prosecution is the executive branch of the state. Prosecutors are part of the executive branch, and so the state gets to pursue charges on its own discretion. And in a situation, I think the onus would be on the family of this sex trafficker to try to pursue prosecution, or some kind of, I don't know, in a society that we envision, Kyle, it would be, it wouldn't be a monopolized system like the state decides whether or not they're going to charge this. And I think the answer is almost always yes. A homicide was committed, we're going to charge it. And this goes back to Rothbard. I mean, talking about wrongful convictions and pretrial detention. If you decide to charge this out and you ultimately lose at trial, well, there's going to be there's going to be something that you have to pay.
Yeah. And, just to kind of tie this in with the Kevin Strickland, and something I cover on the show a lot, and that is exonerations that happen after, an extended period of time, or for major crimes like homicides, rapes, and stuff like that. And it happens really frequently, Pat, that, the person that the state put behind jails or brought charges against isn't the person that's guilty of the crime. And so, how many more people, I guess, are being victimized, because it's not like the conviction rate for murders is very high, right? As is. So it's not like they're catching everybody that, every murder, they're throwing somebody in jail. That's not what's happening. But even when they do actually arrest somebody, get them and throw them in jail, it's often not the actual murderer. And so how many other crimes do you have going on, particularly like sexual crimes, that, especially if somebody's like raping women and getting away with it, I don't imagine that they're going to stop. And if you keep arresting other people for the crime, which, I'm not saying like all the time, like, one guy rapes 3 women and 3 other guys go to prison, but, maybe one of them, they actually do the rape test, and it doesn't turn up anything, and then the other one, the lady identifies some other guy, and so, and the third woman doesn't come forward or something, so you raped 3 girls and got away with it. I don't know, people probably aren't going to stop, right? And so how much crime do you have going on? How many victims do you have, like Chrystul Kizer, that only exists because the court system can do its job in the first place?
Yeah, that's a good question. I mean, there's the seen and the unseen. I don't know if that's the best use of that phrase, but there is. I mean, we don't know purely how bad a monopoly justice system is. We get hints of it, but I'm sure it's much worse.